All right, it's 1 o'clock and welcome. We'll call this meeting to order. Time now is 1 p.m. Our next item here on the agenda is the land use hearings. And the first item up there is continued from May the 28th, which is the Running Creek RV Storage EDZ 2024-3548. I'll entertain a motion to open it.
Mr. Chair, we need to call roll, please.
We'll call roll, okay? Sure, good.
Commissioner Buck?
Here.
Commissioner Schroeder?
Here.
Commissioner McDaniel?
Here. All right, is there a motion to open the hearing for EDZ 2024-3548, which is Running Creek RV Storage?
Yeah, I'll make a motion to open the land use hearing for Running Creek RV Storage, EDZ 2024-3548.
Second.
All in favor, aye?
Aye.
Aye.
All right, the meeting is now open. Turn it over to you, Jennifer, or to Danny.
All right, thank you. I'm just going to introduce this project. As we know, Running Creek RV Storage, it's EDZ 2024-3548, and this is an item we're continuing from May 28th. The site is located off of County Road 13. It's a 50-acre parcel, and the zoning is agriculture with an EEZ overlay. Project footprint, again, about 22 acres. From there, I'd like to turn it back to you for discussion. The item added was a traffic clarification and another letter from Public Works.
All right, thank you. Is the applicant here? Good afternoon, sir.
Good afternoon.
You would give your name to the...
C.J. Kurz, Tahoe Consulting, representing the applicant.
All right, thank you. Did you get the letter from the county regarding the traffic and the discussion? Did you get that in?
We did.
Plenty of time? Okay. All right, and I'd like to talk about that for just a minute if we can. So there's a lot of concerns about the flow of traffic. You've got some safety concerns there. So have you researched that anymore?
Well, there wasn't anything in the letter that was a change or cause. It just literally was a request or requirement for a left turn. But, you know, we had an original approval letter from Kimley Horn, had an original approval letter from the county. These two new letters are just contradicting those two without any new support for why a left turn would be needed.
I think it was because of sight distance, and especially with the two schools being right there. It was about the sight distance there on the road. So as you come
None of
over
that
the
was
hill.
in the letter, though.
Okay.
So I don't know that that is the reason.
Okay. Commissioner Schroeder, do you have any questions, comments?
Well, this is an interesting discussion here. The letter from Kimley Horn, I would agree, is a little convoluted. It's not being real clear on what they want. Obviously, they wanted it to be kicked to the county for decisions. But as far as some of the highlighted pieces I've seen in this letter, there's some recommendations, but I don't see that there's any hard evidence from them either. So I don't know if there's a way that we can come to a amenable agreement on what would be beneficial for everybody. But I don't see that it's a mandated thing. I think it would be more of a desired turn lane.
All right, thank you, Commissioner Buck.
Well, obviously safety is a concern. I think that's why we've questioned these and looked at these traffic studies in depth. And there's a school district there, there's a hill there, and we just wanted some additional clarification on, you know, a traffic count was never conducted, to my knowledge. And
Traffic count's not a requirement, just some evidence of background data, which we provided.
Oh, that was just one of my questions in regards to our last meeting, was we had a lot of engineers look at this, and no one conducted a traffic count. I don't want to go back into it, and I'm not going to rehash it today. I would like to ask Commissioner Schroeder a question in regards to a comparable or a nearby storage facility on 166. I don't remember the name of that facility. I didn't write it down, but it was one that we recently looked at. Can you talk a little bit about what the conclusion was on that one and how that compares or differs from this applicant?
Yeah, that was with the previous board, County Road 166 RV storage, which was approved with the condition of turn lanes. Based on some of the concerns that's been shared with this one, particularly the proximity to the four-way stop at 13 and 166, the immediate hill that would have to be engaged for a turning RV. Those were the main concerns for that one. If my memory serves me right, it was a little bit bigger. I know it was a bigger footprint for sure, and I think it had more storage spaces than this one. Danny, I don't know if you can remember what that number was, but I think it was a larger number than what's being proposed here.
I could check on that. I'm not as familiar with that project either, but we could look at the number.
So to follow up, it was approved with conditions. What turn lanes? Was it a left turn lane and then acceleration, deceleration?
I think so. I'm not sure. There's also proximity. The reason that would need, we didn't go with a right in, right out at that one, was there was concern of the Running Creek subdivision of RVs turning into the subdivision to turn around, which that wouldn't apply so much on this one. There's not a subdivision real close that people would use to turn around in, I don't think. But that was where we were with that one. The unfortunate thing with putting additional requirements on an applicant is sometimes it becomes cost prohibitive for them to do what they want to do with their property, which is always a concern of mine, and that I think is what happened with that property as well. So that one, I don't know if I was to hear that property or hear that hearing again, if I would vote the same way as I did then, but that was the vote of the board with that one.
Jennifer?
To my knowledge, the County Road 166 storage facility was never approved by the board. I believe it was continued and then the applicants withdrew.
Oh, yeah, I think that's
Just for
I
clarification.
think that's correct. With the discussion about turn lanes. Yeah. Thank you.
All right, Commissioner Bullock, do you have anything else?
Well, I mean, I kind of, sympathize with Dallas's comments in regards to we don't want to put so many requirements on something that it prohibits someone from using their property and developing that property. But we also have to keep in mind, I think safety preempts everything. I can't think of anything other than citizen safety that I'm aware of. And whether someone makes $1 or someone's life is at stake, I'll choose someone's life every day. That's all I have to say on it.
All right, Commissioner Schroeder, any further discussion, sir?
I guess not right now.
Okay. Thank you, sir.
For clarification, I heard XL decel. I know that you guys were referencing County Road 166, but for this project, the way that the latest letter from the county reads is that you're recommending full movement access / turn lane at access location. So we're talking about just a left turn lane or an XL decel in addition?
It was my understanding it was both.
Okay, so left turn lane and XL decel.
Yes.
Okay. That's not how this is written. That's why I wanted to get clarification.
Is there any proposal that you would like to make to us?
I'd have to have a quick conference with the applicant.
I propose we have a 5-minute recess.
Okay, we are in recess for 5 minutes. Thank you.
Thank you.
Okay, we'll call this meeting back to order, and for the record, all commissioners are here and present.
So given the fact that we're still not totally certain if we're talking about XL, decel, in addition to a left turn, since that's specifically what the letter says, I think it would be fair if you guys would allow another continuation, give us time to work with staff, try to get a clarification on what that is exactly, but also we would need to work with staff to get an approved design that we could then determine, do we need additional land? Do we need easements? How much is this going to cost? We're dealing with Gold Creek. Do we have to deal with FEMA? All these are implications with what you guys are asking for. Makes it difficult today to agree to this without knowing what those requirements are. So our request would be a 30-day continuation with the expectation that we would work with staff and get an approved design in place that would allow us to look at all those requirements.
Okay, give us just a second.
So you're proposing a July 9th date or a July 23rd date?
I mean, I think staff needs to weigh in on this. They're a big part of it. We can't really work on our, costs and impacts until we know we've got an approved design. So if we can get a design into them next week, as long as they can get something back to us within 2 weeks.
So what about this? What if we set it for July 9th, and then if you see that you're going to need to extend that time, and maybe you could let us know that, we can work with you on it?
That's fine.
Would that be, do work through Jennifer? Would that be all right?
I'm not sure who I'm working with now. Is it going to be Road and Bridge, Public Works, Jennifer?
Well, it's going to be Jennifer, but that'll be your point of contact.
Okay.
Any objections? We need to do this in form of a motion. All right, so a motion to continue this to July the 9th at 1 p.m. Is there a motion?
Sure. I'll make a motion that we continue Running Creek RV Storage EDZ 2024-3548 till July 9th at 1 p.m.
Second.
Favor aye?
Aye.
Aye. All right, July 9th it is.
Thank you.
All right, next, we need a motion to close this public hearing.
I'll make a motion that we close the public hearing for Running Creek RV Storage, EDZ 2024-3548.
Second.
All in favor, aye?
Aye.
Aye.
All right, it's closed. Next item on the agenda is a request for subdivision modification for Bighorn Ridge. And my understanding, we do not have to open that up for a public hearing. Go ahead.
Good afternoon, Commissioners. I have a few brief slides on this request. This is a little bit out of the ordinary. It's not a public hearing. There's not a sort of official process outlined in the regulations, but I'll kind of go over what's being requested, and then I'll turn it over to the applicants to give you some additional details. So the property we're talking about was recently rezoned to AR. This is the Bighorn Ridge. We've recently received a plat application for it, and the request is to modify a standard that's outlined in the Elbert County subdivision regulations for the maximum length of a cul-de-sac road, or a road to a cul-de-sac. Here's the language from the regulations, Article 11B4, subsection B, local roads leading to a cul-de-sac providing access to lots more than 1 acre and less than 20 acres in size shall not be more than 1,320 feet in length. So the subdivision regulations do outline that the Board of County Commissioners can approve a modification from these regulations. And a modification should, the what it outlines is that they should not be granted if it would be detrimental to the public good or impair the intent or purposes of these regulations. There's no other approval criteria outlined in the regulations. Just a quick overview of where the property is. It's highlighted here in teal. It's 80 acres right on the western boundary of the county. So you'll see on the screen the roadway concept that's being proposed. There's an access easement from Ponderosa Lane, which would extend down to serve access to the proposed 7 lots. The requested modification would allow for the road length to extend up to approximately 2,700 feet. And just to clarify, the applicants are looking for direction from the board if this road length would be found acceptable. This does not approve the plat. The plat will still go through the normal review process and still come back before the Planning Commission and the board for a formal determination on the plat itself. But the applicants have indicated that they would like to get your direction on the requested modification for the road length. So the modification has been reviewed by the county engineer in Public Works, and the county engineer does not have an objection to the modification. There was a note that, of course, the road would be required to be built to Elbert County construction standards. There's also a letter in your packet from the Elizabeth Fire Protection District, and they are also in support of the request. The applicant is here to discuss the request with you and answer any questions. Staff's also available if you were to have any questions.
All right, thank you. Mr. Schroeder, do you have any questions or comments, sir? All right, Commissioner Buck?
No comment, no questions.
Okay, so we need to give some direction here, so will we consider it going forward?
Yeah, I recommend we approve the modification, and based on what the fire department says and based on what our Public Works says, I don't think it should be an issue.
Okay, is there a,
Well, do we want to have the applicant have an opportunity to speak?
sure, is the applicant present?
Good afternoon, Commissioners. Grace Erickson, Providence Consulting Applicant Representative. Also present are Gary Hansen, owner and applicant, and Kevin Roth, the engineer for the project. Jennifer summed up the request nicely. This is a low-density agricultural residential development. A road of this length is necessary to serve larger lots that have a longer lot length. You have our recommendations from fire and engineering, and we also have our engineer present if you have any technical questions.
I don't have any questions, sir. Do you have any?
You guys came prepared, though.
We are.
Thank you.
Okay. Pretty cut and dry, so is there a motion to grant or give direction and give permission for them to extend and then bring it back before the board?
Mr. Chair, I move that we agree to the modification for Bighorn Ridge request.
A second.
All in favor, aye?
Aye.
Aye, all right. Motion carries. So the next 3 items on the agenda deal with the Bijou Met Tower, number SUR 2024-0109, SUR 2024-0114, and 2490. I'd like to ask the board if it would be okay if we can consider all these together, since they're all basically at the same location.
I have
Any
no
objection?
objection.
All right,
Yeah, no objection.
okay.
So, Mr. Chair, I'll move that we open a public hearing for the following: Bijou Met Tower, Warhol, SUR 2024-0209, and Bijou Hills Metrological Tower and Chambers, SUR 2024-2590, and lastly, Bijou Hills Tower, Hurtnecki, SUR 2024-0114.
Okay, there's a motion. Is there a second?
Second.
All in favor, aye.
Aye.
All right. Now, with that being said, we'll turn it over to the staff.
All right, good afternoon. I will be presenting Bijou Hills Meteorological Towers, MET Towers, SUR 2024-0109, SUR 2024-0114, and SUR 2024-2409. The following 3 agenda items will be presented together. Each agenda item will be for the purpose of permitting a use by special review for the installation of a meteorological tower for the collection of wind and other environmental data. Each tower will be located on a separate parcel with separate ownership. However, each application is identical in regard to the applicant, the nature of the proposed construction, and the proposed SUR restrictions. The only difference is that the Hurtnecki Tower is 81.3 meters, while the other 2 towers are 60 meters. So again, the site size are various sites. Zoning for each parcel is agriculture, and the request is to approve an SUR for the installation of a MET tower. This project began with a pre-application meeting May 22nd of 2024. There was a community meeting July 23rd of 2024. We recently held our Planning Commission meeting May 20th, and here we are today for the Board of County Commissioners meeting June 11th. All noticing complied with Elbert County zoning regulations 14-day advance notice with a newspaper notification published in Ranchland News on May 1st. Mailed notice sent to surrounding property owners within a quarter-mile radius, and a public notice sign posted on each subject property on May 5th. So here you can see a large overview of the county with the 3 locations. There at the bottom of the screen is Simla. That's the closest incorporated town. The Worrell property is on the southwest corner of County Road 93 and County Road 90. The Hurtnecki Tower is south of County Road 90 and west of County Road 105, and the Chambers Tower is south of County Road 102 and east of County Road 149. That's that yellow star furthest off to the right on your screen. So I'll get into the details for each tower. The first special use area we'll be discussing is the Worrell property, and that is SUR 2024-0109, and the tower is 0498. It's a 320-acre parcel with 2 quarter sections, so it's kind of catty-corner. It's an interesting property. 160 acres are in Section 9, and 160 acres are in Section 17. Currently, there's ranch lands with a pole barn there, no other development. Kimberly Worrell is the property owner, and this will be accessed from County Road 90. The closest residence to the tower is over a half-mile away. Here's a look at the property zoning map. It will be located in that property there with the star, so that's 160 acres, and then this is actually part of the same parcel up here. So again, 320-acre parcel zoned agriculture, currently undeveloped and is grasslands. The land is used as livestock grazing primarily. There are 3 properties owned by Hurtnecki Farms and Robert Hurtnecki that are adjacent to this property. These properties include a 720-acre property to the west and south, a 160-acre property to the east, and a 560-acre property to the north. The subject property is located roughly 3.5 miles north of Elbert, El Paso County line, and about 10.5 miles driving from Simla. Immediate surrounding properties are all ag and ranching properties. The agricultural zoning will not change with the approval of the special use by review. Here's a look at the aerial. And moving in where the tower will be located, right there at that push pin, about 1,000 feet, 960 from the north property line and 384 feet from the eastern property line there. Look at the exhibit and the location. Again, 960 feet to the north and 384 feet to the east, nearest property lines. The next tower location is the Hurtnecke Tower, and that is case SUR 2024-0114, and the tower number is 0598. This is another 160-acre parcel, and currently it's unimproved ranch lands. This will be the 81.3 meter tower, and the property owners are listed here. There's several. The access for this property will be via County Road 90, and the closest residence is over 3/4 of a mile from this location. Here's a look at the zoning map. Currently zoned agriculture, as are the properties that are surrounding it. Properties that are adjacent include a 402-acre property to the west, 160-acre property to the north, and a 1,120-acre property to the south, and 40 and 200 acres to the east property sizes there. Here's a look at the aerial and the general tower location. This subject property is located also about 3.5 miles from the Elbert-El Paso County line and about 5 miles or 8.5 miles driving, 5 miles direct, but 8.5 miles driving from Simla. Immediate surrounding properties are all zoned agriculture and are all ranching properties. Again, the property's agricultural zoning will not change with the approval of a special use by review. Here's a look at the approximate location of the tower, 408 feet from the north property line and 895 from the eastern property line. And a look at the larger parcel and the SUR detail. And the final request for a tower is the Chambers Tower, SUR 2024-2490. This is on a 640-acre parcel, complete section. This is also unimproved ranch lands, and this will be a 60-meter tower, 197 feet. The property owners are Delvin Chambers and Jolene Chambers, and it will be accessed via County Road 102. The closest residence to this tower is about 3/4 of a mile. A look at the zoning map for this 640-acre parcel, currently used for livestock grazing as a primary activity. There are 3 properties adjacent to this one, including a 5,561-acre property to the west, a 640-acre property to the north, and a 795-acre property to the south and east. This subject property is located roughly 3 miles north of Matheson via County Road 149. Immediate surrounding properties, again, all zoned agriculture and ranching. The property's agricultural zoning will not change. Here's a look at the proposed location, with the tower being about 250 feet from County Road 102 and about 1,200 feet from the eastern property line. And a look at the property in its entirety with the SUR detail. Now, to give a little detail onto what these will look like, this is a typical meteorological tower. Each SUR will consist of a tower about 200 feet, with the 0598 being a 266-foot tower. Again, the purpose of these towers is to collect wind data that will be used, potentially design a future wind installation project in Elbert County. These towers are strictly for meteorological purposes, and they will not broadcast signals of any kind. Each tower will be mounted on a small platform and suspended via guy wires. The tallest one will be required to have a light and will be painted different bands of color for federal aviation rules. There's also a small solar panel mounted on each tower for power and a data logger. So for a little more summary on these, the setbacks that are required are at least equal to the height of the tower, and the single permitted use would be a meteorological tower. There's no parking areas, and there are exclusionary fencing around the guy wire anchor points and the tower base itself, cattle panel type fencing to exclude any livestock. So there will be a solar aviation light for the taller tower. The towers under 200 feet are not required to have any light. No landscaping is proposed and none is required. The applicant did implement some best practices related to bird-friendly communication tower toolkit, and that's from U.S. Fish and Wildlife Service 2022 guide. A little more about these. Upon removal of these towers, the special use entitlement shall also be removed from the properties. Grading and vegetation removal are not required for installation of these towers. So these were sent on their first referral period from February 20th to March 13th, and the applicant responded to all relevant comments. The main revisions included updates to the special use by review exhibit, following some U.S. Fish and Wildlife guidelines to protect migratory birds, and addressing other general planning related comments. There was a second referral from April 8th to the 21st and was limited to Elbert County Public Works and Planning Department. The applicant finalized plans for access and addressed final comments from planning after that. The applicant did address all referral comments and concerns. The referral response letters and resubmittals were included as attachments to the packet. In terms of public comment, there were 4 residents at the community meeting. The discussion was generally positive, and there were some questions about duration of these towers, how long they're going to be there, some livestock watering in towers, how will livestock and wells interact with these, and what these towers are generally for. There was one comment during the Planning Commission meeting that was in favor of these towers because there's a similar tower in the area already, so a neighbor spoke about that. During Planning Commission, they voted 6-1 in favor of recommending approval, and these were a few of the conditions of approval that they mentioned or voted with. That the first was that the towers should be decommissioned and removed from the subject properties within 120 days of any lease ending, conclusion of data collection, or project cancellation. They also suggested that the Board of County Commissioners discuss a potential timeline for the special use by review. One number being thrown out there was 5 years. And then the third condition was that in the agenda packet provided to the board, there was inclusion of an updated deed with the landowner's name on it for the Worrell Tower property, and that was included in your packet. So they've met that condition already from the Planning Commission. The one vote against recommending approval was because the Planning Commissioner did not want to have a time frame on a business as to how they were to conduct their business, so they didn't see any reason for having a timeline on the special use. Otherwise, they would have voted yes. Moving into approval criteria for special use by review applications. The first is A, that the use is in harmony and compatible with the surrounding area and neighborhood. These meteorological towers, Met towers, are compatible with the surrounding area and neighborhood. The land use table requires that non-commercial antenna support structures over 120 feet in height receive a special use by review approval in the agricultural zone. Non-commercial antenna structures are the closest like use in the land use table that can be compared to the Met tower use. Additionally, Met towers were deemed compatible with the area with approvals for towers in 2018. B, the use will not have an undue burden on available infrastructure. Elbert County Public Works Department reviewed the application and had no objections. The construction of the tower will consist of a 3 to 4 member crew who will be on site for a day, maybe two, to install the tower. The towers are self-powered and require no additional electricity, water, or other utilities, and minimal maintenance and supervision. C, the use will not unduly increase traffic congestion or burden the existing road system. The Road and Bridge Department with Public Works reviewed the application and had no objections to the special use. Temporary access points for the installation of the Met towers is acceptable, and no permanent access upgrades are necessary. D, the use will not cause air, odor, water, noise, or light pollution. The uses proposed are not believed to cause significant forms of pollution. There is a light at the top of the 266-foot tower that conforms to federal aviation regulations. And E, all sanitation requirements will be met. Elbert County Public Health reviewed the application and had no objections. These tower sites do not require any on-site wastewater treatment systems. F, the use will be adequately buffered and screened. The towers are positioned with significant distance from any improvements. The closest residential buildings are thousands of feet from the tower locations. G, the use will not otherwise be detrimental to the health, safety, or welfare of the present or future inhabitants of Elbert County. These uses will not be detrimental to Elbert County residents. The Big Sandy Fire Protection District was a referral agency for the application and had no objection. Staff sees no concerns related to health, safety, or welfare related to these special use by review towers. Finally, H, all supplemental standards are met, and these supplemental standards for antenna structures over 120 feet have been met. And these are a few of the supplemental standards that it complies with FAA, FCC, and CDOT regulations. Yes, they do. The applicant has filed notice with the Federal Aviation Authority, and the FAA provided the determination of no hazard on August 27th of 2024. The tower will not broadcast any radio waves. The tower is not in an environmentally sensitive area, and the tower is not along or near any state highway. 2, it meets setback requirements with the base of the tower no closer than the tower height, and that the guy wires are protected. All the guy wires will be protected with exclusionary fencing to protect them from vehicles, pedestrians, livestock. And as you saw with the sighting, they're all further than their height to any property lines. 3, based on federal communications memorandum, local governments are only allowed to promulgate and enforce restrictions that are needed for safety or historic preservation. That doesn't really apply to this. So restrictions based on safety and historic preservation have been addressed generally, but again, that doesn't really apply to this case. And 4, in the interest of Community safety, the Elbert County Communications Authority will be included in the list of referral agencies and shall be granted space on all commercial communication antenna support structures. The Elbert County Communications Authority, ECCA, was included in the list of referral agencies. They had no response to this one. So based on the review of the approval criteria found in Elbert County Zoning Regulations, Article 3E5, and the findings in the staff report, the Planning Commission recommends approval with conditions for the Bijou Hills Met Tower SURs. The conditions are as follow. Number one, the applicant will be required to remove the public hearing signs within 14 days of a decision by the Board of County Commissioners. 2, the SUR will not become effective until all fees are paid, conditions of approval are met, and the SUR exhibit is recorded. That includes a 2% cost of construction fee that they will pay to Elbert County prior to recordation. And 3, recordation of all appropriate documents to occur within 180 days of Board of County Commissioner approval. And 4, the applicable Federal Aviation Administration and Federal Communications Commission regulations shall be adhered to during the life and existence of the tower. That includes the coloration and the light that's included on the taller tower. These are the additional conditions recommended by Planning Commission. I didn't include them in those conditions, but if you'd like to add these, that is up to your discretion. The first is that the towers are decommissioned and removed from the subject properties within 120 days of any lease ending, conclusion of data collection, or project cancellation, and a suggested timeline for the special use by reviews to be considered by the Board of County Commissioners. An example for that was 5 years. And then the third was in the agenda packet, an updated deed with the Worrell landowner name is included, and that was completed for your packet. I'll leave these on the screen, and the applicant is here to discuss any questions you might have as well. Thank you.
All right, thank you. We'll ask the applicant to come up. Good afternoon, sir. Give us your name, please.
Good afternoon. My name is Matthew Pagan with the Bijou Hills Wind LLC project here. First, Danny, thank you for your presentation. Good afternoon, Commissioners.
Good afternoon.
I think Danny did a really good job of summarizing our project and what we aim to do here. But just to wrap it all up, I'll be here for questions, of course, but we're really just looking to deploy 3 temporary meteorological towers that are going to measure different environmental data points in the area. It's very low impact to the land, and we've gone above and beyond throughout this process to engage folks in the area, as well as to adhere to the different standards as requested by all the different agencies. So just wanted to say thanks for your time, and I'll yield the floor to any questions.
All right, thank you, sir. Appreciate it. Do we have any public comments? Going once. We got one?
City Mills, 27310 Forest Ridge Drive. My question is, it's used for a wind installation project to monitor, I guess, wind speed. And of course, this is critical to the power pathway and whether it will be safe and how fire insurance will be affected here in our county. So I'm just wondering when we'll have data, and will it come in time for the project?
Thank you. Any other public comments? Sir, would you like to address that question?
I'm not exactly sure the best way to answer that, other than what I can comment on is that our deployment of our 3 temporary Met towers have no basis or relation to the Colorado Power Pathway. So, there is no relation there. Thank you.
All right, thank you. All right, any discussion, any questions from the BOCC?
Yeah, I have a quick question. Was it necessary to do 3 separate community meetings because of the distance, Or did you just combine it into one?
That was combined into one, yeah.
Okay. The only other question I have for the applicant would be number one on that list in regards to the towers being decommissioned. Would that be something that you had any objection to or any thoughts on?
Yeah, that's a good question. Thank you, Commissioner Buck. And I appreciate you taking the time to look at these additional stipulations that the Planning Commission set forth. As Danny mentioned, one of the planning commissioners did abstain or vote against this because of these additional stipulations. That member did not think it was fair or within the regulations to put these additional stipulations on a business. Of course, as a business, we would, and a private company, we would agree to that, and we would be opposed to these stipulations. However, we are amenable and we do want to work in good faith with you all and with the county. And so what I would suggest is for the first stipulation here about the decommissioning, we have worked with our team to see if that's feasible, and we would agree to that. We will say that we will have it decommissioned no more than 120 days after the life of the lease. The second point and the second stipulation becomes a little bit more sticky for us because of the risk with the project for these towers and the uncertainty, and we just don't know if we're going to be able to obtain all the data in a certain amount of time. So for that reason, we would strongly recommend and appreciate your consideration of not including a timeline for the SUR on this application. For the first reason being that it's not in agreement with some of the other Met towers that are already deployed in the county, so there would be a disequilibration, between the two. I botched that word. And then the second reason, of course, is that, like I mentioned, we do have all in purpose and intents of decommissioning these within a certain amount of years. But it's a little hard for us to pinpoint an exact date and time, and so we would ask for you to respectfully consider that. Thank you.
I was really referring to just the first one as far as the decommissioning.
Yeah,
So,
absolutely. We agree to that. Thank you.
Commissioner Commissioner Schroeder?
I don't see a need for either one of the conditions, and I'll explain why. Number 5, on talking about whether the decommissioning and removal of 120 days, I'm not sure as a county we want to get in the middle of an agreement between an applicant and a landowner. That seems to me it would be between the applicant and landowner to work that out with their contract. And for us to artificially insert ourselves into that business transaction, I do not think is appropriate. It's not our contract to get in the middle of it. And on top of that, that would create enforcement issues for us, exactly how that would work. If we have this as a condition of approval and it goes past the 120 days, what enforcement action takes place? It's more burden on the county, and it truly is just a transaction between the applicant and landowner. So I would be opposed to adding that condition. As far as a 5-year timeline on the SUR, this is and it would actually be an extended amount of time for an SUR. SURs can be reviewed annually to make sure that they are in compliance and can have the SUR revoked if the conditions of approval are not met. So it seems to me that this is granting even an extended period of time over what we have. And as you mentioned, it's a open-ended, to put a hard deadline, timeline on the end of it, I think is inappropriate for us. If the project needs to extend, the SUR is in place, it can extend. And then again, that is between the landowner and the applicant, and a business transaction for them that I think we should stay out of.
All right.
I would just like to make one comment. I agree with Mr. Commissioner Schroeder on both counts. Thanks for the clarification.
All right. Any other questions? Discussion?
I have none.
All right. With that being said, I'll entertain a motion at this time to approve or deny.
Would staff prefer 3 separate motions on this or a combined motion?
They are 3 separate SURs, so we have a resolution for each one.
For each one?
Yeah.
Okay. And they do not include the recommended conditions of approval?
Just the 4.
Just the main 4. So the applicant agrees to those main 4 on all 3 applications?
Yes, sir.
Very good. Okay, I move that we approve Bijou Hills Meteorological Tower, Hurtnecki, case SUR 2024-0114.
Is there a second?
Second.
All in favor, aye?
Aye.
Aye. Motion carries.
Mr. Chair, I move that we approve the Bijou Meteorological Tower, Worrell, SUR case 2024-0109.
Is there a second?
Second.
All in favor, aye?
Aye.
Aye. Motion carries.
And Mr. Chair, I move that we approve Bijou Hills Meteorological Tower, Chambers, SUR 2024-2490.
Second?
Second.
All in favor, aye?
Aye.
Motion carries. All right, thank you. Entertain a motion to close this public hearing.
Thank you, Commissioners. Appreciate it.
Mr. Chair, I'll move that we close public hearing on all 3 of the SURs for the meteorological towers, Chambers, Worrell, and Hurtnecki's numbers, SUR case numbers 2024-2490, 2424-0109, and 2424-0114.
Your second?
Second.
All in favor, aye?
Aye.
Motion carries. Thank you. Next item on the agenda is a Kiowa disconnection. County-initiated rezone on the Digby property. This is case number RZ 2024-901. Is there a motion to open this public hearing?
Yeah, Mr. Chair, I recommend we open the public hearing for the county-initiated rezone Digby property RZ 2024-901.
Second.
All in favor, aye?
Aye.
Motion carries.
Right. Good afternoon. This is a county-initiated rezone, and the case number is RZ 2025-901. The site location for these includes 3 parcels. They're adjacent to Kiowa to the south here. The parcel numbers are listed above, and the site size is approximately 113.5 acres. The proposed zoning is A, agriculture. The applicant is Elbert County, and the request is to rezone from an undefined zoning classification, it was Kiowa plan development zoning, to an Elbert County zoning classification, which would be agriculture. Brief history on the background of these properties. They were annexed into the town of Kiowa in 2002. There was a planned development in Kiowa that did not occur, and these properties were removed by decree in 2024. The location there, right here in Kiowa, there's our county, and they're right outside of Kiowa here to the south. Immediately north of the subject properties are residences along Shasta Court within the town of Kiowa. To the east of the properties is County Road 45 and a 1,877 acre property owned by Harmony Land and Cattle. To the south of the properties is a 70 acre property with a residence and several outbuildings that is zoned agriculture. And to the west of the properties are a 502 acre property owned by Harmony Land and Cattle and a 4.2 acre property with a residence that will remain within the incorporated town. Here's a look at an aerial of the properties. These are not within the floodplain. There are no wetlands on the property, and the access would be either via Ute Avenue or County Road 45. Here's a look at the 3 properties together. So, brief timeline on this one. The board Board of County Commissioners initiated the rezoning February 19th. There was a referral, the error there, just from March 20th to April 10th. There was a Planning Commission May 20th, 2025, and here we are today for the Board of County Commissioners. All noticing complied with Elbert County zoning regulations, and that included 3 consecutive weeks of newspaper notifications. With Ranchland News, there was no sign posting or mailed notice for this project. These departments reviewed the project, and all comments have been addressed. There were no real comments during the referral period. There was no public comment during Planning Commission or before. The Planning Commission hearing can be summarized by brief discussions about why this is required, that this rezone will not impact existing easements to the property that remains in Kiowa but's disconnected in a way or buffered by this property. This rezone can be done by legal description only, as is allowed by our regulations. There's no exhibit necessary, and the Planning Commission recommended it for approval with a vote of 7-0. So, our findings, not necessarily review criteria, but findings related to our criteria, is that it is generally consistent with the goals of the comprehensive plan. The process, again, for all county rezonings can be summarized as follows. The Board of County Commissioners, Planning Commission, or Board of Adjustments may at any time direct Community and Development Services to initiate rezoning. The Board of County Commissioners, again, initiated this in February, and I was assigned as the case manager. This proposed rezoning does conform to and is generally consistent with the goals of the comprehensive plan. Elbert County strongly supports private property rights that encourage agricultural land uses. This rezoning should be compatible with the higher density residential property within the town of Kiowa and compatible with the large lot agricultural and ranching properties that surround the properties to the south, east, and west. B, the proposed rezoning will not adversely affect the provision of public services. No additional services will be required, and no development is currently being considered for these properties. C, the rezoning will not adversely impact the environment. E, the rezoning will not create unreasonable traffic congestion or burden existing road systems. F, this will not be detrimental to the present or future inhabitants of Elbert County. There's no determination of impact to health, safety, or welfare of present or future inhabitants of Elbert County. Again, Planning Commission recommends approval of rezone 2025901 Kiowa disconnection, which is a county-initiated rezone, the Digby rezone, also known as, and there are no additional conditions of approval. And that concludes my presentation for this county-initiated rezone.
Okay. So are there any public comments? Seeing none, we'll move forward. Any additional questions from commissioners?
Would the applicant like to speak?
Applicant present, who's the applicant? You're going to be it, Danny?
The county is the applicant
county's
for this project.
Cool.
This is really a matter of necessity only. When it was de-annexed from the town, it left it with no zoning, and we need to zone it so that it's a zoned property within Elbert County.
Okay. Any discussions from commissioners? No. All right, seeing none, we'll ask for a motion to approve.
Mr. Chair, I make a motion, we approve the Kiowa disconnection county-initiated rezone of the Digby property, RZ 2024-901.
Second.
All in favor, aye?
Aye.
Motion carries. Motion to close this public hearing for RZ 2024-901.
Mr. Chair, I'll make a motion, we close the public hearing for the Kiowa disconnection county-initiated rezone, Digby property, RZ 2024-901.
Is there a second?
Second, with a point of clarification, perhaps, the draft resolution that I have says it's RZ's 2025-901 versus 2024? 2025. Is the correct? Okay.
2025 is the correct, yeah.
So with a friendly amendment to the motion, I'll make it the 2025 and second.
Yeah, thank you for catching that. My paper says 2024 as well.
Mine too.
All right, all in favor, aye?
Aye.
Aye.
Aye, motion carries. All right. Now we need a motion to close this public hearing. Sorry, we just did that, didn't we? I'm confused. All right, next item on the agenda is the presentation for EC West Metropolitan District's consent to SID formation. And this does not require public hearing.
Good afternoon, Commissioners. I'm just getting this pulled up for the applicant. It has to be difficult at the end of the day. There we go. I apologize. I did not bring my clicker. I'm happy to click through the slides for you.
Oh, thank you so much, Jennifer. We really appreciate it. Good afternoon, Commissioners. My name is Paula Williams. I am with the law firm of McGeady, Becker, Cortez, and Williams. I'm here with Marianne McGeady in my office, and our office serves as general counsel to the EC West Metropolitan Districts numbers 1 through 5, the EC West Commercial Metropolitan District, and the EC West Water and Sanitation District. We also have available members of Colorado Ranch and Land Holdings, Jim Yates and David Gallo. We have Jonathan Heroux, who is with Piper Sandler, who's an underwriter, as well as Michael Wolfesberger, who is with Independent Engineering Services. And what they do is they provide an assessment of the improvements that will be constructed potentially by a SID and the level of benefit that they provide to the impacted properties. So the reason we're here today is to request the county to consent to the formation of a SID. The metropolitan districts were formed in 2024. The Board of County Commissioners approved service plans for each of these districts. Contained within the service plan, there was a provision that allows for special improvement districts to be formed so long as we obtain the written consent of the county to the formation. So it was contemplated at the time the service plans were approved that special improvement districts might be formed. There are a couple criteria in the service plan that have to be satisfied. If the county allows us to form a SID, the SID must, if they impose assessments, those assessments must be fully paid before a certificate of occupancy is issued. So what we wanted to do today was to describe to the commissioners what a special improvement district is, why we're asking for it to be formed, and then how it will actually operate. So I will provide a little bit of general information on SIDs, and then I'll ask Jonathan Heroux with the underwriter who can go through how SID financing actually works. So the EC West Metropolitan Districts cover 1,464 acres of property at roughly County Road 29 and County Road 176. They're slated to have residential development that includes up to 2,850 units. And the improvement costs associated with this development are significant. At the time of service plan approval, estimated public improvement costs were $376,375,898. So a special improvement district is an entity that is formed by the Metropolitan District. Title 32 allows metropolitan districts to form SIDs within their boundaries, and they're formed as a method to fund local improvements. And the mechanism for funding those local improvements are through the issuance of assessment bonds that are repaid by the properties that are specifically benefited by those improvements. And so we're looking at, over the course of development, potentially forming one or more SIDs to fund the in-tract infrastructure. So the spine infrastructure, which benefits everybody within AC West, would be supported by general obligation bonds, tax bonds that everybody equally gets taxed on. And then the water and sewer improvements would be funded through the water and sewer district. So these would be really truly local improvements to be paid for by just the lots that are benefiting from those improvements. But as I mentioned, the assessments have to be paid prior to a certificate of occupancy, which means homeowners are not going to get burdened with this. And really what the benefit is with such a huge infrastructure need, this allows access to tax-exempt financing at much more favorable interest rates than if a developer had to go out and get private financing. So it bridges the gap for a period of time and has no long-term impacts on future residents, meaning the liens are fully paid before a resident moves into that house. A special improvement district is governed by the board of the Metropolitan District, and we have to act within the boundaries of the service plan parameters that the commissioners approved last year. So with that, Jennifer, if you would go to slide 1. So I think I mentioned that it's an alternative to traditional development loans. Title 32, which is the Special District Act, does in fact allow for the formation of a special improvement district. We are governed by the Metropolitan District Board and subject to the same parameters that the commissioners identified when it approved our service plans. And then again, the assessment bonds are repaid through special assessments that get imposed by the district on just the lots that are benefiting from those improvements. So at this point in time, Jennifer, if you would go to slide 2. I'm going to go ahead and ask Jonathan Heroux with Piper Sandler to come up and kind of go through some of the advantages of the use of special improvement districts, as well as how the financing actually works. And then I'm more than happy to answer any questions.
Sure. Can you give me an example of some of the localized improvements that might be done by this district?
Sure. Michael, come on up. Michael Wolfesberger is with IDES, and they're the engineers that have been engaged to really look at some of the improvements that are contemplated to be funded with the assessment lien bonds and how the lots specifically benefit from those improvements.
Thank you.
Hello, my name is Michael Wolfersberger, and I'm with Independent District Engineering Services. The main improvements that will be funded by the SID will be the local streets and storm sewer improvements throughout all of the filings that are being constructed at the moment, or planned for at the moment. Any other questions for me at the moment? Thank you.
I got a question. Just streets and storm sewer projects?
Primarily, yes, and there may be earthwork included as well. We are still going through our benefit study to determine the exact improvements that we will be recommending funded by the SID.
All right, so what happens to the SID when everything's paid for? It just goes away?
I would defer to Paula for that.
Yeah, that's a great question. The SID is being formed primarily to focus, well, to fund the public improvements. So when its bonds are paid off, it will essentially dissolve, and the district would adopt a resolution declaring its intent to dissolve the special improvement district.
And you said that this would be done before the homeowners move in?
The lien on each lot would be cleared before a homeowner moves into that lot. So if there are, right now we're looking at the first 422 lots that I believe plats have been approved for. And so when homeowner one moves in, the lien associated with that lot has to be paid. And so depending on how long it takes to sell all 422 lots, it may take a little bit of time. But for each homeowner, they will not have to, their lot will not be burdened by the assessment lien of the SID.
Understood. Thank you.
Sure.
Commissioners, you have any? Commissioner Schroeder?
But I would assume, though, it would increase the cost of the home because the developer, the homeowner, or the builder is going to pass that amount on. They're not going to.
So I'll ask Jim to talk about it, but theoretically it should actually decrease the cost of the home. Because if you think about the improvements have to be constructed, and if the developer had to construct them and go out and get private financing at a 10-12% interest rate, it would cost them more to construct those improvements that would get it factored into the cost of the home. Whereas if the SID builds it and is able to finance it at a tax-exempt interest rate that is much lower, then the same cost of those improvements is less that would be included within factoring into the home prices.
That makes sense to me. And then, so this is just for the initial construction of the roads and gutters, and from then on out, the Metro District will take over the maintenance of those roads and gutters?
I believe that is correct, that it is intended that the metropolitan districts will be the entity for the ownership and maintenance of those roads. But let me just make sure. Oh, hi, Jim. There we go.
So for the record, Jim Yates with the applicant. Yeah, so it's just a substitute for private equity. So it's a way of lowering the cost of financing, the cost of money to get that initial piece of infrastructure built. I think, as you recall, this is the first project, I believe, that will take all of the road maintenance internally. So instead of dedicating that to the county, that'll be dedicated of those internal roads that include storm facilities and all of, kind of that offsite. Will go to the district, and then the district will own and maintain those roads.
Okay, that makes sense. I appreciate that clarification.
Commissioner Vogt, do you have any questions or comments?
Not at this time.
Good afternoon, Jonathan Hiru with Piper Sandler. We're in Denver, and we are the underwriter working with the applicant on this transaction. I think Paula did a nice job describing what an SID is. On this particular page here, we're talking about, some of the benefits, and I think the primary one is it's a lower cost of borrowing. And a lot of that has to do with the lien being put on the land as opposed to Metropolitan District, which is simply applying mills to a property, but there's no hard collateral. So from a tax exempt standpoint, based on recent history in Colorado, a borrowing rate is someplace between 5 and 6%, which is certainly lower than private financing or bank financing. We're able to amortize this debt over a 20-year period. What's not been touched on so far is that each lot, when the lien is cleared prior to a homeowner taking ownership of the property, those proceeds go to repay the bonds. So in a traditional metropolitan district, you're amortizing bonds over 30 years, and we may have a call feature of saying 5 or 10 years, which means you can refinance at that 5th or 10th year. In a SID, assessment lien transaction, you have the ability to turbo or repay this debt very quickly as each lien is cleared. So to Paula's comment, when you get through the final 442nd lot, all the liens are cleared, all the bonds can be repaid. So while we amortize them over 20 years, depending on how quickly those lots are absorbed, those bonds could be repaid in 4, 5, or 6 years and be extinguished. And then at that point, the lien is gone. And if the Metropolitan District had issued debt, those mills are really the only obligation from the district to the homeowner, aside from the overlapping mills that the county and the school district would be levying. As I just mentioned, you're paying down the liens as each lot is sold. It is something that can be used in conjunction with general obligation or LT, limited general obligation debt. As the cost of development has increased over the years in Colorado, applicants, developers are looking for ways to keep housing costs low, and their cost of capital is obviously one of the big driving forces. So being able to use this type of financing, tax exempt, along with limited geo bonds is advantageous, ultimately to the applicant, but also to the homeowners at the end of the day. I think it's been touched on, each dollar that's raised by the SID, it's being used for in-tract or very similar tax exempt eligible expenses for projects like this. So it's all for public improvements, public benefit. Maybe the next page, it's what we're trying to show here on this chart is simply kind of a flow of how this financing through a metropolitan district is generating proceeds and kind of how the proceeds are being used. And then on the left side, what you're seeing is bonds are being repaid, Metro District bonds, through those mills over time. Whereas on the right side with SID, you have the assessments being repaid or cleared, which is how those bonds are being repaid. And, again, this is not an extra burden ultimately on the homeowner. The lien will be cleared. There will be no mill levy plus a lien still outstanding on those properties. Maybe financing example. I actually think maybe, we can stop here. In terms of how these are structured from a bonding standpoint, what we do is we look at what the finished lot value will be. So once all the improvements are done, and then is common in the public finance markets today, investors are willing to accept what we call a 3-to-1 lien. So in this example, we have a lien amount of $41,000. What that's basically saying is that finished lot value would be approximately $123,000. So, and in this example, we're showing a 20-year financing at 5.25% interest rate, fairly traditional structure where we borrow interest. That's what we call capitalized interest in this model, as well as the debt service reserve fund. And at the end of the day, we're able, in this example, based on the number of units and the 3-to-1 lien, to generate, significant project fund dollars in the blue line there, $15.6 million. which is applied towards, the public improvements that need to be made for each lot in the project. Maybe the next page. Lots of numbers on page, which is always easy for someone who calculates the numbers, but sometimes hard for the audience to follow. What we're kind of showing here is that on the right-hand side of the presentation, in our example, this was 500 lots, and in our example, we're showing 100 lots each year are being cleared or sold ultimately. And so what it's showing is that you're able to repay the 20.5 million of principal very quickly because you're seeing an interest column. You're only paying interest on the bonds while the bonds are outstanding. On the left-hand side, what we're showing is if this took the full 20 years to be repaid before all the lots were cleared, you obviously have a higher interest cost that's associated with that debt. Again, this is the ability to repay these bonds very quickly as each lien is cleared is very advantageous from a true total cost of capital and a repayment cost for the applicant. And I think the final 2 pages are 2 case examples that our firm has worked on, not yet in Elbert County, of course, but relatively close. One is the Sterling Ranch Community Advisory Board. We worked on a transaction for them back in April of 2024, where they decided to issue limited geo bonds as well as assessment lien bonds at the same point. And a very similar discussion happened at Douglas County in terms of their approving, reviewing a presentation much like this. I won't necessarily go into all of the specifics there. In that particular case, they had a higher finished lot value in perhaps the second bullet point from the bottom. They were able to raise more capital in that transaction. Each of these transactions are ultimately based on the finished lot value of a specific project. But another, I think, well-financed project that used this additional tax-exempt tool to the advantage of the applicants and ultimately the homeowners. And then I think the final page, this is a project we worked on in Parker called Hess Ranch. This one was an SID financing alone. They had already issued their limited geo bonds, and slightly different finished lot price points here, but again, the same 3-to-1 lien value, and again, similar use of proceeds for what we call the in-tract improvements. And that's really what I had for the presentation. I'm happy to answer any questions.
Mr. Schroeder?
Just to make sure I'm understanding, the assessment that is assigned to each lot remains static throughout the life of the SID. In other words, that the 41,000 example we had, home 1 is assessed that, but 5 years down the road, home 300 is assessed the same value. It's not a...
If it has roughly the same finished value price, yes.
So it could move?
Well, if you, in our example here where we showed that $41,000, that was assuming every lot had a finished lot value of $123,000.
Okay.
So if you had a lot that was, certain lots were bigger homes, let's say it was $150,000 on that particular lot, that would be a $50,000 lien there.
And that'll be established when the...
That would be established in the day when the bonds, oops.
From day one?
Yeah, from day one. It doesn't change over time.
Okay, thank you.
Commissioner Buck?
Yeah, once the debt is cleared and the lien is gone, let's say a number of years go by, 421 homes have been sold, the lien is no longer there, but the SID is still in existence.
Well, I think as Paula noted, yes, it would still be in existence, but it's not really doing anything at that point. The debt has been repaid, so it's really just the metropolitan district that would be in operations at that point.
So to follow up with that, contractually, does that SID have any authority to incur any additional debt at any later date? Is there anything in the contract that gives them, because if they're still in existence, or if it just, does it have a sunset on that contract once those So what kind of what I'm asking is what happens after the?
Yeah, no, that's a really good question. So the SID has to live within the parameters of the service plan. The service plan says the SID assessments cannot be paid after a certificate of occupancy is issued, meaning the assessments have to be paid beforehand. And so in order for the bonds to be fully repaid, you have to have homeowners living there, right? And certificates of occupancy issued, because that's what triggers the payment. And so if our service plan says we can't issue assessment liens on anything that has a certificate of occupancy and all of the property has a certificate of occupancy on it, there wouldn't be any trailing obligations. And so when the bonds are paid, the Metropolitan District would essentially adopt a resolution essentially dissolving that particular special improvement district that financed the improvements, and there are now homeowners living there.
Okay, thank you. You answered the question.
Okay.
Sure.
So just to clarify one thing, what we do when we do development, we sell lots to builders. So we're typically not going to wait, and we cannot pass that obligation. We can legally, but the builders won't take that. They have to have clean title. So it's likely that we will be faster than what you see here. We're not going to wait for houses to get built to clean that title. When we sell lots to builders, then that's when that gets cleared. And that usually kind of comes in larger chunks. So all those lots will get sold to builders before, the 422 homes get built.
Well, I think the reason I was a little bit confused was because I think she mentioned that at some point the road maintenance might be transferred to the SID versus the Metro District. Yes. So I was a little confused.
Yeah, so.
I'm sorry,
yeah.
I should have, if I misspoke, I apologize. Once the SID is only a financing tool, once the roads are constructed, it'll be the Metropolitan District that owns and maintains.
Okay, thank you. I was confused by that.
I apologize.
No problem.
Yeah, so we have call it an overlay district, but a district that kind of sits over the whole property. That's who will maintain the roads. Once they're built, then they get inspected. There's a warranty period, just like the county, and we'll follow the county process, basically.
All right. My notes here say that we don't have to take or shouldn't take a vote on this. Is that correct?
That's correct. No action today.
All right.
Okay.
We get to come back and see you, I believe, on July 9th. But thank you very much for the opportunity. We really appreciate it.
All right. Thank you. All right. Is there a motion to adjourn?
I'll gladly make a motion to adjourn, Mr. Chairman.
Second.
All in favor, aye.
Aye.
We're adjourned at 2:30 p.m.